All right, we're going here on Chapter 12, the Law of Agency, Lesson 8, and we're continuing. And we've got right now, page 9, question 450. Paul signed a power of attorney giving Audrey the right to sell his sailboat for a minimum of 25 grand in his absence. Audrey sold the boat to Teresa for 20 grand. What is the legal result? The answer is 1. Paul would succeed against Audrey for damages for breach of the agency contract. Sucks to be Audrey. 451. An agent's authority can be created retroactively by his principal by an action called 2. Ratification. So ratification will allow a principal to create an agency's authority retroactively. 486. Which of the following would be relevant in determining whether an individual was an employee or an agent? And the answer is 4. All of the above. What are all of the above in determining whether an individual was really an employee or really an agent? 1. The contract which exists between the alleged agent and the alleged principal. 2. The degree of control the alleged principal has over the alleged agent. And 3. The method of remuneration of the alleged agent. Question 525. Where a principal adopts a contract that the agent entered into without any authority, then we're going to 525. Sorry, I lost it. The agent is given authority retroactively to enter into the contract. So again, where a principal adopts a contract that agent entered into without any authority, that's stupid. 3, the agent is given authority retroactively to enter into that contract. Wow, that is amazing. 10, 550, where an agent with authority enters into a contract with a third party and does not disclose that he or she is acting as an agent, then number 1, 550, the third party may sue either the agent or the principal to enforce the contract. Where an agent with authority enters into a contract with a third party and doesn't disclose that he or she is acting as an agent, number 1, the third party may sue either the agent or the principal to enforce the contract. 561, an agent owes a duty to the principal not to make a secret profit. This means that an agent must keep the principal fully informed about 3, all of the actual benefits and prospective benefits accruing to the agent in the transaction. No secrets. 581, a standard multiple listing service contract must, 581, be in writing. Number 1, be in writing. A standard MLS contract must be in writing. And we go to page 11, 582. You as a trading services licensee working in a hot market have recently listed a property for sale at 850 grand. An offer at 840 grand was received at 8:30 this morning. At noon, a second offer of 845 grand was received, and a third offer of 850 grand at 2:30 in the afternoon. You will be seeing the seller at 7 this evening. Which offer is to be presented? And 582, the answer is all the offers. All the offers have to be presented. 619, an agent will be personally liable to third parties to where the agent fails to disclose that he is an agent. All right? You are liable to third parties if you fail to disclose you're an agent. 657, and where a principal adopts a contract which his agent entered into without any authority. 3, the agent is given authority retroactively to enter into that contract. So you, all right. If the agent enters into a contract without authority, principal adopts that, then 3, the agent is given authority retroactively to enter into that contract. 12, some long ones happening here. 661, Ellie, a licensed real estate rep, entered into a written exclusive contract with Laura to list Laura's house for $300,800. Shortly after entering into this agreement, Ellie's license expired. Unaware of the expiration of her license, Ellie proceeded to hold 3 open houses and numerous other showings of the house, eventually finding a buyer who made an offer of $300,800. Laura accepted the offer, but when she learned about Ellie's license expiry, she refused to pay any commission to Ellie. Which of the following statements are true? 661. Number 1. Only C and D are true. And what are C and D? C, a court will not award Ellie any form of remuneration in this situation. And D, based on the limited facts in this situation, it appears that the listing contract complies with the statutory requirements of the Real Estate Services Act, the RESA. 667, Quan, a real estate licensee, completes a listing contract with Betsy Smith to endeavor to effect a sale of Smith's property for $250,000 payable in 5 equal annual installments. In return, Smith will pay Quan a flat fee of $10,000 if a suitable buyer is found. Quan feels the property is worth $190,000 market value. Green makes an offer to Smith through Quan of $250,000 cash payable on a completion date. Which of the following statements are true? And the answer is 2. Statement A is true. The other 3 statements are false. So statement A, Quan may advise Smith that Green's offer exceeds Smith's stated price in the listing contract. So that is true. Everything else is false. 13. 680. In which of the following situations will the agency authority continue to exist? 684. None of the above. And so what are these none of the above things? A, Lauren lists his house for sale with Steve. The house burns down. Well, there's the end of your agency authority. B, Lauren enters into an exclusive listing agreement with his agent, Mark. Lauren then sells the property himself without Mark's assistance. C, Lauren enters into a written listing contract for the sale of his house with Brad. Brad dies. D, Lauren tells his agent over the phone that he no longer has the authority to sell his house. All right. So the answer to all these questions is 4, none of the above. None of these have agency authority continuing to exist. 682. Which of the following statements is true with respect to contract listings? And 4 is none of the above is true. All right. 1. While a listing contract is a contract between the brokerage and the seller, the buyer is bound to some of the terms contained in the contract. That's not true. 2. It's not necessary that an exclusive listing contain a specified duration or commencement date. No, that is also false. 3. The open listing provides better protection for the agent than the exclusive listing, and that is also no. 688. Robert asked Whitney to act as his agent at the auction of the effects of a deceased rock star. Robert was an enthusiastic fan of the deceased and tells Whitney that no matter what, he must become the owner of the deceased's vintage Rolls Royce, which is painted in a most attractive paisley motif. Whitney is also told that under no circumstances is she to come away from the auction without buying this automobile for Robert. At the auction, the Rockstar's paisley Rolls Royce is offered with a second pin-striped version of the vehicle. The 2 vehicles are offered as a package, and accordingly, Whitney, as the successful bidder, purchases both vehicles for Robert. If asked to discuss Whitney's scope of authority, you would correctly answer that during the course of the fact pattern, Whitney was provided with 688.3 both express and implied authority. So she had both express and applied authority to buy the desired paisley Rolls Royce and also the pinstriped version. Weird, huh? Page 14, 720. Assume that a seller instructs his real estate licensee to make certain oral representations regarding a property which both the seller and the licensee know to be false. If the purchaser later sues the seller and the licensee on the basis of this misrepresentation, then 720, the seller, number one, the seller will be liable to the buyer because he explicitly authorized the tort. 722, Sally, a listing licensee, agreed with an aggressive purchaser that Sally would give part of her commission to the buyer in the event that the buyer's offer for Whiteacre was accepted by Jacob the seller. This arrangement will result in a quick sale of Whiteacre for the price stipulated in the listing contract, which is what Jacob desperately needs. And the answer is 3. Only statements B, C, and D are false. So because it's asking what are false. B, C, and D. B, disclosure to Jacob by Sally is not required because the commission is Sally's to do with as she pleases and she's not making a secret profit. That's false. C, Sally should have told the buyer to offer a lower price which she could recommend to Jacob rather than reduce her commission. That's also false. And D, assuming that all the terms in the listing contract are met by Sally, she will be entitled to commission when this deal closes. That's also false. B, C, and D. And A is true here. It is the duty of the listing licensee to get the best price for the seller. That's true. Alrighty then. So we go to page 15 and question 728. Deborah is a trading services licensee. After providing her best estimate with respect to the value of Susan's property, Deborah lists the property at $600,000. Jennifer, who has learned that Susan's property is situated in the middle of an area to be redeveloped, immediately comes to Deborah with a full-price subject-free offer. In response to Deborah's surprise at the instantaneous results, Jennifer acknowledges that a redevelopment of the area is intended. Deborah does not advise Susan of the redevelopment, as it might throw a spanner in the works, and in any event, she feels that a redevelopment might cause the value of Susan's property to decrease rather than rise. Susan accepts Jennifer's offer and is delighted that the property sold so quickly. Analyze the following such statements. And the answer is 3. Which of the statements are true? A, C, and F. A, Deborah has breached her duty to Susan by not advising Susan of the proposed development. Yes. C, the proposed redevelopment might have affected Susan's decision to sell her property and therefore should have been brought to Susan's attention. Yes. And F, Deborah could have suggested that Susan consider canceling the $600,000 listing and relisting at a higher price. All those things are true. A, C, and F. 761. Steve Ann, a trading services licensee, has been asked by her friend Jean to find a house, and if successful, Jean has agreed to pay Steve Ann the sum of $3,000 over and above any commission that Steve Ann would earn on the sale of the property. Where Steve Ann finds a house acceptable to Jean, Steve Ann shares the commission with the other licensees involved and receives $3,000 directly from Jean. Steve Ann does not tell anyone of this $3,000 payment. Which of the following statements are true? And the answer is 1. Steve Ann has breached the provisions of the Real Estate Services Act. Because Steve Ann should not be taking that $3,000, right? Is that wrong to take the $3,000, or is it wrong to not share or tell anybody? I don't know. We'll have to check it out. 16. Question 860. Which of the following events will terminate the real estate agency relationship? And the answer is 4. An act of the principal which is inconsistent with the continuation of the agent's authority. Dust. So that will terminate a real estate agency relationship. 4. An act of the principal which is inconsistent with the continuation of the agent's authority. I think we asked that already. 863. A trading services representative must never promise to buy or sell any real estate belonging to a prospective buyer, 863, 1, unless at the time of making the promise, a signed statement setting forth the details of the promise is given to the person to whom the promise was made. So you shouldn't promise to buy or sell unless when you made that promise, you put a signed statement. Signed statement, everybody, 863. 867, which of the following is false? An agency's authority to act on behalf of his principal may arise, number 2, contingently. Didn't we already talk about that? Your authority to act on behalf of your principal may arise contingently. No, it's not contingently. But it is, these other things are true, expressly and by implication and by ratification. Those are all true. But contingently, no. Or as we used to say, no. Page 17, 891, an agency contract can be terminated in one or more of the following ways. And 891, the answer is 4. All of the above are true. 1, agency contract can be A, by the death of one of the parties, B, by the legal doctrine of frustration, C, by the letter of termination by the principal, and D, by the insanity of the agent or the principal. Those are all true. 911, which of the following statements concerning an open listing is false? And 911-2, the Real Estate Services Act requires all listings to always be in writing. That is false. Really? That is false? 911? Okay, Real Estate Service Act requires all listings to always be in writing. So it's not, the RESA doesn't say that. But 1, this is true. Under an open listing, a commission will only be paid to the agent who is the effective cause of the sale. That's true. And then 3, and under an open listing, the seller is free to dispose of the property independently without any liability to pay commission to an agent. That is also true. And 4, under an open listing, a seller is free to use the services of any number of brokerages. That is also true. But the thing that's false is that the RESA requires all listings to be always in writing. 923, in which of the following circumstances will an agent not be personally liable for his or her actions? And the answer is 1, the agent identified as such is mistakenly believed by the third party to be contracting as a principal. So in this situation, the agent will not be personally liable for his or her actions when 1, the agent identified as such is mistakenly believed by a third party to be contracting as a principal. Imagine that. Page 18, 933, a prospective buyer signs an offer on a property for $250,000 and mentioned to the listing licensee that she would be willing to pay as much as $270,000 for the property if necessary. The listing licensee presents the offer to the seller without mentioning that the buyer may be willing to increase the offer. The seller accepts the offer of $250,000. Since it is not a dual agency situation, this fact pattern is 933. 2, a breach of the agent's legal and ethical duty of full disclosure to her principal. It's a breach. All right, it's a breach. 967, when an real estate agency relationship is created. 4, none of the above are true. These all are lies. 1, the interests of the agent takes priority over those of the principal. Lie. 2, the buyer of the property is always owed the agent's primary duty to act solely for his or her benefit. Lie. 3, the agent is an employee and works under the direct control and supervision of his or her principal. Lie. All right. 976. Where a principal of an agent has acted in such a manner as to lead third parties to believe that the agent has authority to perform certain acts of belief on behalf of the principal, and a third party deals with the agent in the bona fide belief that the agent has that authority, the agent is said to have 976, drum roll please, apparent authority. So that's apparent authority when authority is apparent. And then we're redoing 151. Usually a licensee's commission will be paid for when the transaction has been completed and the title is transferred. So that's when your commission will get dropped into your bank account for when the transaction has been completed and title is transferred. Thanks for the listen. folks.